So I think earlier on, one of you mentioned about the client turning back to you and say, "Hey, this is additional time. You're wasting my time." So the question is, should there be LD imposed on architects? I mean, we do have this in a clause for contractors, right? If they don't miss the deadline and etc. Is that something that is reasonable to consider to be imposed on architects as a service provider, as a professional?
Interesting idea.
No, so diplomatic. Who asked the question? Who asked such
Do you have an interesting answer?
No, I have an interesting answer because the
Mine's very boring.
LD requires a certifier, right? A judge.
Exactly.
Who judges the LD
Yeah.
for architects? It can't be the client. He's the claimant, right? So
The client can only if he's willing to pay for a third
sure,
party.
external third party which will complicate time.
Yeah,
and money.
exactly.
You can.
Yeah, you
But
can.
then,
I'm not stopping
of course, I have to defend my profession, right?
Yeah, of course.
I think
Yeah.
that is the baseline for there shouldn't be any LD for architects. They already have means to control you through late payments, holding back your payments. Yeah. So those are the ways that I think it's already it's rather fair already, which is. But then I think no LD to architects doesn't make sense for me.
Yeah, I agree. Definitely, I mean, from architect's point of view, you don't want to get yourself in that situation when a client has because sometimes even when you have clauses like that, then it becomes very difficult because they may just attribute everything to you being late for something. Yeah, and we don't want to get ourselves in that situation. Yeah, which is also why I guess the blue book, right, that we have for SIA doesn't have something like that.
Of course.
Yeah, it doesn't make sense. Yeah, for us to get into that kind of trouble or that kind of situation. And like in terms of the way that we structure our payment should already be an assurance to the client, because it's not like we are claiming ahead of the work that we are supposed to do. It's always by the stages, how much work we complete, and also milestone stages. So we ourselves, we should be also motivated to want to reach that milestone so that we can make the claim. So that should already be sufficient, for the client to feel confident that we will be doing our job. So it doesn't make sense for us to get into that. Yeah.
This question got us all excited.
I'm sure clients will over the fence. I'm sure clients will ask. But it's also the complication of who's going to certify it. And then it doesn't also make sense because if they really want to claim from someone who is not doing their duty from an architect, there are other channels to do that as well. It could be, of course, a civil kind of thing. Could be a.
But maybe not even at that level. Just to add on, right? Yeah, that's one point, right? Is the external. You need an impartial external certifier to see whether we are in delay. But I think the other one would be there's a board of architects. It's a regulated profession, so there are avenues in which we can be penalized for being shoddy of our work. That already is just like the avenue for builders is through LD. And that's only if the owner chooses to impose the LD. We don't have the power to do that, right? So I think different professions, different parties of the construction industry, each of them already have their own controls or regulations that will penalize them. So to further impose LD onto a professional practice like architecture, when there already is a BOA, not so sure.
But actually, the question is, so obviously I get the sensing that everyone is opposing to such a thing, such an LD, but the question is, would an LD be a blessing in disguise or not? Because to be honest, we can't say that all architects are going to be good, right? There's definitely good and
not
bad. Definitely there will be good and bad, right?
Yeah,
so,
for sure.
Or even a situation where we have done everything that we could, but then it somehow, the fault falls onto us or something. But would the LD then limit the claim from the client? Like, for example, if there was no LD rate specified, the claim could have been exorbitant. But if you set, if there's any delay through our fault, this is the rate, and you set, you have the right to set the rate that you're comfortable with, which is lower. Would it be something?
It's to me, I feel that again, back to the original point, right, which is, I think notwithstanding the fact that there could be some bad hats, so on and so forth, but ultimately, it is still over and above that in which there is a professional body. And that is the avenue in which the client or whoever else who may be dissatisfied with our service, and if rightly so, they have an avenue to feedback to the body, which will then in turn do an investigation and penalize us. This is just another different form of penalty compared to LD on the contractors. And essentially, if there already is a form of penalty, it doesn't make any more sense to further layer it on with other forms of penalties, because it borders on being unfair, right? So I would take that approach. Yeah.
Agree. Yeah, I would rather that because bad hats, I think I would choose to believe is a minority. So yeah, I think BOA and also the clients themselves, they can take legal action, and I don't think there is a need for something like that to be in the service agreement.
Yeah.
Definitely.
Yeah, because we should also not we should also get into the project not setting ourselves to fail. It seems to be quite a strange starting point. Yeah, to say that, oh, I think I may be late for this, and then I will set a very low rate. Yeah, to get myself. Yeah, it doesn't quite work for me. Yeah.
I had this situation, just to share, right? I went in for a tender. So the organization has this LD clause for consultants. We had this briefing, right? And then they flash out these slides. And it says LD for consultants. I think it's $300 a day, 300. So I looked at it and then I asked, does this apply to us? And yeah, of course, yeah. So I said, usually you don't LD us because of the board of architects already. We're under the board of architects, so if there's any issues, you just go to them, then penalize, blah, blah, blah. So then I also asked them, under what circumstances do you impose this LD? I'm just curious. And they said, oh yeah, for example, if you're late in your submissions. And then before I could respond, the person explaining, right, quickly came and said, but I know a lot of factors are at play. We cannot entirely just pin it on you. So this is just something that we put in the contract. Don't worry, we won't impose on you, but you'll be there.
Oh my god.
So I said,
that sounds
that's not quite fair, right?
yeah.
So then the team, another person came out and mentioned that, oh, you know what, if you're not happy with this, you just don't bid for it. So it was a very, it's almost like a deterministic statement. So I didn't bid for it. I actually wrote in to SIA about it.
Yeah.
I mean, I'm okay if you put it in, but you explain to me so that I know how I should perform. But if you tell me, oh, it's always been there, don't worry, you won't impose it, that's not very assuring. I feel.
Yeah, it's not sure.
Yeah, my fear is that it becomes a client's weapon and it may cloud your decisions to make a professional choice on. Cutting corners because you're fearing of this money imposed, LD imposed on you, and I think it should be left out. And as it is, like Alvin mentioned, there's already a mechanism in place. So that's our answer to this.
So I mean, with this whole topic about reputation and financial losses, so Robert Bosch of the Bosch company, you've ever once said that you would rather lose money than lose the reputation. So what are your thoughts on such a statement?
He must have done something right to start with. I think what he left unsaid could be that, and it applies to a lot of things, right? Which is, if you look at something in isolation, then it doesn't quite make sense. If I look at a single project and I'd rather lose money than lose my reputation, you lose a lot more, because if it's only just one isolated project. But as a business, in terms of managing your risk, and this is not just for architecture, right? You're going to have a wide spread. You're going to hedge your bets, right? So you've got a few different projects, different stages. So I think, I'm in no position to criticize what he says, but I think he probably said in the context of, I've got this huge company, certain things I can make a loss, but that client is important to me. I want to service a client. It's okay, I can cover it with the other ones. But that's his business risk. So I think there's no right or wrong to that statement, but it has to be seen in context and in the context of a business. If I only have one project and I've got to pay my bills, oh, for sure, I'm just going to service a client. But you manage your risk. That's my take.